All right, so for the next few minutes, we're going to talk about some ethical and legal considerations as it relates to diagnosing and considerations around diagnosing, as well as documentation. We're also going to talk about some legal and ethical considerations for technology use as well. I'm not sure that you get that anywhere else in the program, especially given that telehealth is such a big um, and emerging modality for therapy. So we're going to cover some of that too. You're not going to find this, of course, in the DSM. You're only going to find this here. I'm going to give you links to additional readings that I've gathered this information from. Some of it's come from some personal trainings that I've attended. For example, I think I mentioned that I am a board certified telemental health therapist. And so I've pulled some things in from that training to provide you surrounding legal and ethical considerations of telemental health therapy from that. So, yeah, pay attention and let's jump right in. All right, so we know this is not an ethics course, and you will get this information in another format, of course, in your ethics class. It'll be much more expanded upon, but I did want to briefly, hold on. Anyway, so yes, I did want to provide just a brief overview to get us all on the same page. We've got our ethical principles here, as well as some examples of some ethical codes, right? Our guiding ethical principles are like the philosophy that undergirds, our practice, right? And the ethical codes are kind of like our specific, laws, for lack of a better term, that govern the way that we practice and considerations around that, okay? But I like to think of those in that way, right? That these principles are kind of philosophical in a way. It's our philosophy for how we approach the work that we do. And of course, let's remember we've got beneficence, non-maleficence, autonomy, justice, fidelity, and veracity, okay? And when we're thinking about applying this to diagnosing and treatment planning, selection of treatment, documentation, we have some really interesting considerations here. For example, talking about the diagnoses that we're selecting with our clients, right? Informed consent, in other words, giving them power through their treatment in, using our clients as a tool to help us come to our diagnosis and making sure that everyone's on the same page and is in agreement with that, right? Now, there's not always going to be, it's not always going to be the case that your client is going to be able to agree with you in that way, right? Like that is a best practice, of course, but that's not always going to be able to be possible. But I did just want to briefly remind you all of these principles here. All right, these next two slides go over different types of laws that affect us as service providers and the way that we provide services and how we provide services. And the first is statutory law. I've got some examples here. These are statutes around reporting, right, as well as confidentiality, those types of issues. So you can really think as statutory laws as those laws that are keeping our clients safe as well as us, right? Some of this is regulatory to maintain that we are safe and not, liable for anything that comes back on us as well. Case law, of course, this is law that goes into effect after some landmark case has been decided, right? Like the famous one that we always talk about is the Tarasoff case with duty to warn. Okay, we've also got regulatory law, and of course, this is regulations that are governed by government and state agencies, the Department of Health and Human Services, child welfare, and mental health agencies. So as you can see, we have many, many, many different levels of law affecting us that come from different places as well. But it's not just a cut and dry, there's one entity that is governing us or overseeing our body of work. It's, state, federal, all of these smaller municipalities as well that we really have to pay attention to. We've also got constitutional law and executive orders that at times we've got to pay attention to as well. Right now, I don't believe there's anything on the books as far as executive orders that is necessarily affecting our work, but that is something that can affect, um, you know, counselors work in specific states, right? Like if the governor of, let's say, Mississippi, because this happened, if the governor of Mississippi were to put in effect an executive order about providing services, um, you know, to those who were not citizens, that's something that would indeed affect our practice, and that is something that we see happening in certain states, particularly more conservative states, right? So again, many different things to consider. And sometimes it can be hard when you're practicing in the field to stay abreast of this information as it's changing. It changes really quickly. This is why it's so important to stay plugged in with professional organizations, right? Because it's a lot. The landscape of the field changes all the time, sometimes for the better, sometimes not. But, you as one person, it's going to be really hard to stay on top of all of these moving pieces in this conversation. So again, just another feather in the cap of urging you or encouraging you to join those professional organizations and join in some of the larger conversations around ethics and law affecting providers in the field. So when we're trying to tease apart law versus ethics, obviously both are intended to protect the entities that we care for as well as ourselves. So even though our ethical values and our legal principles are usually very closely related, our ethical responsibilities usually supersede our legal duties. And so if there is a time where the law and the ethics go against one another or, contradict one another, as a professional counselor, you are to lean into that ethic, our code of ethics, over the law in that case. And if it were to rise to the level of going to court, right, you would be able to show where you would be able to show where you had acted in accordance with your professional guiding ethics, right? Our ethics are a body of codes and documents, of course, at the national level, whereas laws, we've got federal laws and we've got our state laws. But again, those ethics written at the national level do supersede laws in cases where it contradicts. This is why documentation is so important, because you've got to be able to make the case that you were acting and behaving in a way that was ethical, right? In a way that you were achieving or trying to achieve beneficence and non-maleficence in these cases, right? So I just want to put that out there. Okay. And we've got three perspectives really when we're looking at this debate of law versus ethics. We have some people who are in the staunch camp of law should be obeyed regardless, right? If I'm going to, I'm not going to break the law and just for the fact of being a professional counselor, right? The second perspective is, we have to work within the law while working to change the law. Okay, that's a good one. That's a really good one. We can see where that would be a really good choice. The last one here would be in the case of unjust laws, or again, where they contradict. Again, those ethical responsibilities should supersede your legal duties. Okay. When physicians or clinicians believe that a law violates an ethical value or is unjust, you should work to change the law. The ethical code says, in exceptional circumstances of unjust laws, ethical responsibilities should supersede legal duties, right? So that's written in our codes, okay? Another one that comes from our code. Conduct that is legally permissible may be ethically unacceptable. Okay, so legally we could do this thing, but our ethics say we shouldn't. The code in those instances said the fact that a physician who has been charged with allegedly illegal conduct has been acquitted or exonerated in criminal or civil proceedings does not necessarily mean that the physician acted ethically. Okay, let's tease that apart a little bit. Just because a clinician has broken the law and they've been exonerated or they've been acquitted doesn't mean that the physician acted ethically. So just because they didn't break the law doesn't mean that they were ethical. All right. So we've got to break these two apart. There's no simple solutions to these types of ethical dilemmas. We've got to bring our critical thought and our reasoning to these situations. Some clinicians may even disagree within the field on what to do with these situations, right? So you may be in a tough situation and decide to consult, and you may get 3 different answers on that. And again, as far as documenting those answers, you should document each one of those answers, how they were different, who they came from, and the date. And that is showing that you've made and are making a good faith effort to weigh out and think critically about your decision making surrounding your client, right? Okay. So as I was saying, yes, some clinicians do embrace the view that all laws should be obeyed regardless of the service provider's personal opinion about their reasonableness. Now, from this perspective, those who believe that typically believe that an orderly society requires strict obedience to laws. Otherwise, we risk social chaos. Okay. However, I would like to point out again that social service providers have a right to seek changes in the law, but we don't have a right to violate the law, right? So this is again where that comes into play of having to, you're really in this place of a dilemma of like, oh my gosh, am I going to break the law and uphold the ethics? How am I going to work this? Okay. The other side of that, though, is that some social workers do resist this blind obedience to the law because of their belief that some laws are unjust and harmful. Okay, and these types of providers, service providers, argue that professionals must use their professional judgment and, if necessary, engage in civil disobedience. Okay. So teasing apart these 3 perspectives a little bit more here. And ultimately, like, I can't tell you what is the quote right way, all the time right way, because that doesn't exist. Again, this is a gray area where you have to exercise a lot of judgment. You know, what is right in one situation may not be considered right in another situation. So again, you can't apply the same problem-solving skills in exactly the same manner to every case because there's always going to be some contextual piece that makes this case perhaps a little different from a previous case, right? So each case is very individual in that regard with related to how you might respond and what decisions you might make around the law and the ethics there. All right, so I have an example here where the law and ethics are in disagreement with one another, okay? Let's say that you work at a community agency that is funded by the state, okay? And there is an executive order put in place by the governor of your state. Perhaps you're in an emergency you're in emergency times regarding state funding, okay? So you're prohibited to see this client in your role as a state-funded therapist or agent of the state at that point. However, our ethics do mandate that we have to treat all clients that have intent to self-harm, okay? And so with this case, we've got this 32-year-old woman who is an undocumented immigrant who's displaying the suicidal ideation with a recent suicide attempt. We know that recent suicide attempt really ups the ante with regard to uh, potential risk and lethality. Okay, so what would you do in this situation? Again, I can't tell you what is the right and the wrong answer, because this is something that you would need to consult with other professionals. I could tell you what I would do in this situation, but what I would do in this situation um, might not be right for you, and it might get me in trouble with the law, because I absolutely would make the decision to still see the client in this case. But this is just one example where law and ethics would be um, would contradict one another. Let's talk for just a second about civil commitment. We're all pretty familiar with this idea of criminal commitment, right? Where someone is committed to an institution, i.e., a prison or a jail, for having committed a crime. But what about involuntary commitment for other reasons where a crime hasn't happened or hasn't occurred? This is the ballpark that we're in, talking about when someone poses a danger to themselves or others, right? You may hear this referred to as a civil commitment or an involuntary commitment. And typically, if we have someone who is not voluntarily going to allow us to put them in an institution, that I hate the way that just came out, because it was laden with a power differential whereby clearly me as the treating clinician would have power over the client. I'm sorry, that came out in a way that I didn't like. Let's say that our client is unagreeable to being admitted into a psychiatric hospital, though we know that they need that, right? There are laws in place to where, you as the treating clinician can work with the police and your local police, as well as, local courts and the family or social supports, that if they are there, to have someone committed involuntarily, okay, for their own best interest. And we have some criteria for that commitment: that the individual presents a clear and imminent danger to themselves or others, if they're unable to care for themselves or doesn't have social support to provide that care, right? Perhaps if they are unable to make decisions about their treatment and hospitalization, if they have deteriorated, to the point that they can't even make those decisions. And then lastly, that there is an unmanageable state of fright or panic. Now, I will say they have to meet all of these criteria, and this top one is a must. We know that there are people on the streets who are homeless who meet one or more of these last three, right? And we say to ourselves, like, well, that person isn't in a hospital, and we really know that they should be. They're not able to take care of themselves. They don't have an ability to make these responsible decisions for themselves, and they don't have social supports. The thing that's lacking is that imminent danger to self or others, okay? Now, under your supplemental materials for this week, I've posted a link to a PDF for a summary of civil commitment guidelines and processes and procedures for the state of Connecticut, okay? I didn't go to the links to find that for every state that we might have students in, but these are relatively easy to find, but I did go ahead and post that there for you guys to look over. And I may actually pause this in a bit and scoot on over to the website just so that you can see that. Yeah, in fact, let's go ahead and do that here. One moment. All right, so this is the link that I've posted for you guys. It'll bring you here. You can download a copy of this PDF if you'd like. But as you can see here, we have a pretty detailed procedure here, right, with regard to who's able to initiate these proceedings, who is going to be responsible for providing that examination, as far as, if they meet criteria for being involuntarily committed. They will have a right to a hearing, of course. Okay, so I encourage you to look through this. It's not very long. It's just a one-page summary here. Obviously, this becomes very important when we are working with people perhaps with severe depression who might show intent to harm themselves, right? Suicidal ideation, um, severe mental illness, right? People who are in a psychotic state or, on the, have had a psychotic episode, or perhaps even those who are displaying um, uh, bipolar disorder, specifically bipolar 1 with psychosis or deep depressive episode, right? So this is where we think about those types of situations. I'll give you an example from my own personal life, actually. So when I was actually working on my PhD, my best friend and roommate ended up going out with some friends over a long weekend at one point, and getting a hold of some speed, and he ended up taking the speed, and this triggered an underlying psychotic episode that we then had to deal with upon his return. And so basically he went into this psychotic episode. He had this break, and he was, walking around town, completely barefooted for several days, and, starting fires inside the house because of certain delusions that he was having, etc., etc. But the point where it became an issue for involuntary commitment, well, starting fires in the house was the first huge red flag. Like, obviously this poses a harm to yourself or others. But the other one was, the final straw, was where he was actually on campus, talking with like the dean of students over this issue, though it was rather silly because he was in such a psychotic state. He didn't even have his shoes on and was very nonsensical. And he ended up going into the dean of students office and like broke a snow globe and was, talking about all of these race wars. It was quite intense, I will just say that. But at that point, he was very, very angry with pretty much like all white people, for racial injustice, which obviously, like, we totally understood that. He was a sociologist, in addition to living in Mississippi, right? And so at that point, you make the call for the involuntary commitment to the police, to get them on board. And, they found a bed for him. We got him over there to the hospital. And within the week, he had his hearing. And by that time, he was somewhat medicated and had settled down and was agreeable to being hospitalized. But at first, he certainly was not. So it can be quite a challenge to work with those who needs to be in a hospital, but they are refusing to go. Because in this case with my friend, he was definitely refusing to go. Like, this was something that was coming on rather quickly at certain points, and like, of course, I knew what was going on, but until he was a harm to us or to himself, and it reached that level of severity, there was really nothing that I can do without his permission. And I do wonder, like, what would have happened with him had he not had the social support that he had at that time, right? And there's so many people who do enter psychotic states who don't have that support, right? And it's, I'm sure, a much more scary process for them to be involuntarily committed without having someone there saying, like, I know you don't want to be there, but this is the best thing for you, and I'll be here to visit you tomorrow, right? So it's a lot. It's definitely a lot to think about, and a pretty big and serious process. But at the end of the day, of course, we're keeping everyone safe. And just as I mentioned in some previous lectures, prognosis is going to be the best when you can get someone care earlier on in their break or in their deterioration, rather than later. These are the basic procedures for a civil commitment. Pretty much these are the basic steps that you'll see pretty much across states and regardless of where you're at, right? The concerned person or entity petitions the court for examination. Obviously, there's some paperwork involved with that. The judge then orders a mental health evaluation. Typically, there is some sort of mental health therapist or caseworker who is specifically assigned to work with the hospital or hospitals in that jurisdiction. And then that formal hearing is held where the patient is allowed to speak on their own behalf. And then again, if treatment is mandated, a finite period might be specified, like you've got to stay in here until, you get your issues under control. It may be 6 months, it may be a year. Typically, though, the treatment is not going to be that long, right? Typically, insurance is not going to pay for that. And so we don't want to hold, and even the courts recognize like insurance is unlikely to pay for a 6-month commitment to a hospital. And so we'll just say as soon as they're better, we can release this individual. But let me talk about the other side of this just for a moment. Before this number 1, what has to happen is, of course, somehow you've got to call the hospital, or, maybe you've got several hospitals in your area to choose from. You've got to find one that has an open bed and availability for this individual. That's hurdle number 1 of finding availability. Hurdle number 2 is figuring out how you're going to get the individual to the hospital. This is where sometimes you might have to involve the police to get them to the hospital if they're not going to willingly go. Sometimes you may have to even call an ambulance for that, especially if there's health concerns. Of course, that can be rather expensive, but maybe you have someone who, is going to go voluntarily, and therefore you would be able to use your own personal vehicle, right? So just to let you know what that process looks like a bit. All right, let's talk for just a moment about the rights of patients, regardless of what setting they're in, okay? First of all patients have the right to the least restrictive environment, meaning that if they don't need to be in an inpatient facility with 24-hour care and lockdown, we're not going to put them there. Maybe perhaps we can consider a halfway house at this point, or an intensive outpatient program, right? So, meaning, again, that if this is a right of the patient, that means they also have a right to the evaluation for those decisions, right, at any time. Of course, patients have the right to treatment. And this doesn't just mean medication. This also means they have the right to receive therapy, right? Typically, we would think that if someone was being admitted to a mental institution, that they would receive therapy. However, we know that some of these state-run institutions are not run very well. They have a lack of resources, and perhaps they're not doing things by the book. I have certainly encountered many state hospitals like that. And so, again, there may be these instances where the patient, advocates for themselves, or, raises an appeal or a concern of some kind for their own right to treatment. Okay. And then finally, the right to refuse treatment. The right to refuse treatment is complicated because in some cases, some folks have been deemed as manipulating the system to refuse treatment. So, for example, refusing treatment so that they don't have to stand trial due to competence. Okay, that's just one example. There's some other questions kind of raised around this right to treatment, and so this right has actually been extended to the least restrictive alternative to include that treatment. So if patients are allowed to refuse forms of treatment, and if the hospital doesn't have alternatives, can they then sue the institution, right? This is one of those areas that we don't really know, right? Like if they are refusing medication and they want, let's say, equine therapy instead, but the hospital doesn't offer equine therapy, can they then sue that institution? Okay. Of course, we know that someone who is deemed incompetent cannot be executed. But then we think about, like, why would someone who is deemed incompetent agree to take medication only to then be executed, right? That, like, really makes no sense. We know that sometimes medications are mandated for prisoners to make them competent to stand trial, but there are clauses written that say that, again, these medications, quote, must be in the best interest of the defendant. Okay. So this is a lot of ethical gray area with regard to rights of patients. Um, and yes, a jailed individual who has a severe mental illness is also going to be considered a patient in that regard, particularly if that mental illness has to do with the crime that was committed. Okay. So we got to keep that in mind too. I don't know how many of you are looking to go into forensic therapy, forensic counseling, that side of things, but this is certainly a ballpark that you'll be all up in, should you enter that side of the field. All right, so we talked a bit about deinstitutionalization in our intro lecture this week. Here's just a bit more information about deinstitutionalization and what problems that it has caused. So the number of inpatient patients has dropped by roughly 75% since the 1960s and 70s, when the deinstitutionalization movement began. Right, but with that, we've seen a rise in a number of problem areas, like those not receiving treatment, increased rates of homelessness or institutionalization, just, changing the type of facility that individuals are in, from hospitals to prisons. And so I say that mostly to have you think critically about some of these issues, okay? All right, let's talk just for a moment about suicide and the right to die movement. This is another area of legal and ethical concern in the field, right? Where individuals who perhaps have a terminal illness would like to engage in assisted suicide, but then that is deemed illegal, right? This may be one of those areas where we find ourselves trying to balance our ethics and legal issues. But of course, when we're thinking about assisted suicide, then ending someone's life is in question. And so, right, we wouldn't want to get probably tangled up in that legal mess. But this is something that is on the horizon. This is something that there is discourse around in the field, okay? And so if someone does have an advance directive, this will be a written statement providing guidance for medical and healthcare decisions in the event that a patient becomes unable to make their own decisions. But that's departed from someone who is of sound mind and body and able to say, like, my life is just no longer worth living, right? And I want to ask you guys, at what point do we consider life poor enough quality to justify terminating it? Okay, this is very subjective, obviously, and there's really no way to objectify this or make it, measurable or streamlined. What about people who are severely injured or disfigured, right? What about those with intellectual disabilities or severe mental illness? And who decides whether a person is terminally ill? Where's the line of that finite ending, right? People do come back from terminal illnesses every day, right? And so when we start thinking about these cases for XYZ individual over here, where does it stop? Can someone say, well, I've lost both of my legs, so for me, that means life is no longer worth living, so I'd like to engage in this assisted suicide right now. On the other side of that, though, I don't know. Sometimes, we got to think about the way that we treat our animals, right? If we are willing to end the life of our dog because we love them so much that we wouldn't want them to be in such pain at the end of life, Why can we not consider that for humans as well in those stages of in life? I think the main issue around this right now is that we we can't figure out where to draw those lines, and do they exist? If they do exist, where do they exist? Right? Because I've given you some examples here of some areas where, hey, yeah, I think most people could get on board with that, but where does that line stop? Right? So anyway, I want you to think about where you fall on this idea of assisted suicide or the right to die movement. And just think critically about your position on that, and what you might do if you were in certain situations here. All right, so this reading from Kress and colleagues in 2010 gives us some things to think about with regard to diagnosing. And in the article, they note this apparent disconnect between the DSM's approach of the disease model and the ACA's striving toward mental wellness and more of a strengths model approach. And they've noted this forced dichotomy, right? That this puts you in a place where you're having to hold both perspectives in your hand and kind of work between them. Okay. And really what they are in this article encouraging as a best practice is this idea of informed consent and diagnosing. Okay. Informed consent as it relates to what the diagnosis means. And this means that the counselor is to offer enough information about the diagnosis for clients to responsibly consent to that diagnosis and to the treatment that's based on that diagnosis. Okay. Informed consent requires sharing with clients the benefits and the risks of possible treatment procedures before the client consents to participate in these procedures. Of course, we know that. But also including that process of diagnosing in that informed consent. We know that diagnosis can lead some clients to this false idea about who they are, and with perhaps later on despair or upset about falling victim to these self-fulfilling prophecies, right? And I've talked around this in other lectures. So we have to think about the pros and the cons around that. But again, typically a movement toward this informed consent and diagnosing and making our clients, bringing them into that process. Okay. That's giving our clients power through this process in which therapists and practicing therapists really do hold power. So this is an attempt to try to share that power. All right, continuing points from this same article, when we're thinking about confidentiality and diagnosis, we obviously have to record their diagnosis in their medical chart, but there is a potential risk that could present should a client become involved in legal proceedings. Okay, so in some jurisdictions, a judge may deem the client's records necessary to serving justice. So they may subpoena your clinical records that might include that diagnosis. So if our records are revealed during certain court proceedings, the client's diagnosis is no longer confidential. It becomes known to the people who were not intended to be involved in the counseling process. Furthermore, that client's diagnosis may then become part of public record. Okay, so we need to think about that. Another issue with regard to confidentiality and diagnosing. Our diagnostic codes are routinely reported to a central data bank that insurance companies have to check before issuing insurance plans. And clients can actually be denied future coverage on the basis of having received certain diagnoses. For example, someone may see a diagnosis of bipolar 1 and say, nope, this person is too much of a risk to have on our insurance, right? So that's another thing that we have to consider, is that diagnoses do actually follow our clients, and we have to be we have to discuss these issues with our clients, right? So having that discussion of this is going to be part of your clinical file. What does that mean? What are the implications of that? Okay. All right. So one other thing we have to talk about here is uh, around diagnosing, this idea of accuracy versus misrepresentation. Okay, because we know that diagnosing is tied to reimbursement, that oftentimes you have to diagnose in order to receive payment for those services. We know that counselors engage in upcoding and downcoding. Okay. And what happens when we upcode is typically we've got someone who needs to seek therapy and we have to record some diagnosis so that insurance will pay for their sessions, right? I mean, realistically, we can't see all of our clients for free. On the other end of that, we don't want to be lying about what they have. But what we see sometimes is that clients and clinicians will upcode, will, you know, put a diagnosis in a client's chart that maybe they don't actually quite meet full criteria for so that they can get reimbursed and see that client. The other hand of that is downcoding. And this is where someone may not report the full extent of someone's diagnosis so that they may be protecting them from that stigma or protecting them from future issues such as accessing health insurance. Okay. And so this is a really sticky place to be, right? 44, I will note that 44% of counselors who responded to a survey indicated that they had changed or would change a client's diagnosis in order to receive additional managed care reimbursement. Now, when I just read that cold from the document, it sounds like a self-centered endeavor. It sounds like it's centered on payment, right? That's going to pad the clinician's pocket. But it's not just on the part of the clinician. I can honestly say that I have upcoded diagnoses so that I could treat my clients, right? It's not always just like, oh, I'm doing this for my own personal gain. Oftentimes we will see counselors who will upcode so that their clients can access treatment. Okay. This is considered unethical and illegal. I will note that, or illegal. I will say that, to fudge the insurance companies in that way. But our ethics come into play here, right? Like, how are we going to treat someone who is just barely missing the criteria for major depression, but they still have these issues that are interfering with their everyday life? And we have to have this diagnosis or some diagnosis on file in order to continue seeing them. Okay. Very, very sticky situation. When clients, of course, are able to pay out of pocket, counselors are going to feel less bound to the DSM and less bound to diagnosing. Of course, it would be beautiful if we all, in a perfect world, had that freedom and weren't bound by what the insurance companies are telling us to do, but we don't live in that world. This is the system that we are in. So I'm telling you that these issues are out there, these issues with upcoding and downcoding, but I'm also telling you that in many agencies, these ideas of upcoding for reimbursement and so that clients can access treatment is commonplace. Okay. You have to decide for yourself where you are going to fall in that conversation. That's a personal decision for you. Okay. I know, again, all I can do is tell you what I personally did. Working in community mental health with, children from families in poverty who lacked resources. And I absolutely upcoded from time to time so that I could provide resources to families and children and provide that help. That's where I fell on the issue. Absolutely, that could have come back to bite me in the ass big time, right? This is where your license is on the line for some of these decisions, or could be, right? It could call into question your license. However, this is the reality of the field that we live in, and I don't want to paint it as decisions that are easy to make, or decisions that won't have you looking over your shoulder. And it's not all rainbow and butterflies. Like, you do have to make these really, really tough decisions sometimes. So with that, counselors should consider informing patients of potential risks of claiming upcoded diagnoses, such as the potential for incorrect diagnosis to be used by other entities like schools, estranged spouses who may sue them for custody, for example, or other insurance companies. On the other hand of that, though, counselors do need to inform clients and families of the potential legal ramifications of intentional misdiagnosing on either side of that. I have had conversations with clients of, when I have upcoded or downcoded, and that, I think, is for me, sharing that transparency was the best way to go about it. But again, I can't make these decisions for you. I can't tell you which decision is the right decision. That's a very personal decision that has to be made. All right, we've got another reading here, managed mental health care and the issue of intentional misdiagnosis, which we were just talking about. So, we kind of briefly discussed in our first lecture from this week about managed care, and the managed care organizations are like a broker between health insurance companies, patients, and service providers. They monitor, control, and limit the costs that the insurance providers will ultimately have to pay. And so what can happen is that the insurance plan covers 25 sessions a year, but the managed care organization perhaps will come in and say, no, based on this prior authorization, we're only going to allow for 6 sessions this year. Okay. That's a huge discrepancy, 6 versus 25. What can we really accomplish in 6 50-minute sessions? Okay, and so basically we're in this landscape right now where we are having to work between all of these entities to get as much care as we can for our clients, knowing what we're up against. Okay. What we are seeing is that these managed care entities, managed care organizations, we're seeing diminished autonomy on the part of the patient and the service provider. Treatment is modified in many cases to fit the managed care organization. And so that diminishes the client and therapist autonomy, and it doesn't have either the therapist or the client really in mind first, right? Like, the priorities are the needs of the client, and the priorities that the therapist has set really can't be upheld or met, right? We can have this whole conversation about the person who really has the most expertise, i.e. the service provider, making informed decisions on behalf of their client, right? There's a whole conversation to be had around that. Again, this is the system that we are working within right now, and that we are working on the outside to change. But this is where we are, and you guys need to know that's where we are. We talked about prior authorization. If you'll remember, this is the documentation that you or your organization will have to provide on behalf of the client in order to get approval for the services. And so this is where that prior authorization piece is where we see misdiagnosis happening most frequently, right? Trying to make a justification for your client to get more services so that we can meet their needs, okay? So I want to put this out there for you guys. I want you to think about what you'll do in these situations, because you may have that. Let's see. So sometimes we may also go ahead and provide services, and then the managed care organization will deny that reimbursement, i.e. medical necessity for that service could not be established. So the insurance benefits were exhausted and they're not going to pay for it. Okay. Some things we need to consider here. There are some diagnoses that we will discuss this term that are really applicable to low-hanging issues, right? Just like your run-of-the-mill issues that anyone might come to therapy with, that is not like a diagnosed mental health disorder. Adjustment disorder, for one. Relational issues. those are typically associated with longer term services. We also have the Q codes or V codes, what we used to call them. I want to say now they're called Z codes, that have to do with issues like social problems, homelessness, relational issues, abuse and trauma, other conditions, quote, that may be a focus of clinical attention. Now, I bring this up because many of our clients' issues fall into these categories of adjustment disorder, relational problems, issues associated with social services or social issues, right? Many of our clients maybe don't meet criteria for a full-blown diagnosis, but we could say, hey, I'm going to give you this V code or give you adjustment disorder. Well, not so fast. Insurance companies are not paying for these V codes, now called Z codes, or some of these adjustment disorders and relational problems. That's not cutting it in today's system to put that in the treatment chart. So what we are seeing is that insurance companies right now are only paying for the more severe or finite mental health disorders, and it puts us between a rock and a hard place, really. So again, these V codes include, let's just talk about what these V codes include. They include relational problems, problems related to physical and sexual abuse or neglect, adult, child, or adolescent antisocial behavior, intellectual functioning and academic problems, bereavement, religious or spiritual problems, acculturation issues, phase of life problems. That's a lot. That's a lot of the reason that many of our clients come to seek therapy. Okay. So I want you to think about that. An argument can be made absolutely on both sides of this issue. But I say all this just to present you with this issue in the field, and note that it's not always going to just be that you can decide not to diagnose as a matter of your own personal philosophy. Okay. Ultimately, continuing along with this article, ultimately our obligation to our client ethically takes precedence. Okay. There are, of course, legal ramifications that come along with upcoding, as I mentioned. You might be fined. You may have your license taken away. You may be excluded from treating people on Medicaid or with Blue Cross Blue Shield if you are found to be fraudulent. So again, we should, as counselors, advocate for insurance reform. This system is busting at the seams as it is, and something's got to give. All right, we've got another reading here, very recent from 2021, looking at patient access to mental health notes. I do want you guys to be aware that in 2021, there was a what is wrong with my speech today? Neuro Day for sure. There was a federal ruling that requires organizations to share, this is supposed to say share, online access to clinical notes, okay? This brings up a whole host of concerns and considerations for us. Basically, what this is saying is that just like many of you have probably noticed that your notes for your healthcare healthcare practice has moved to an open access, right? Perhaps you have My Chart available now where you can see your test results right there online. That is part of this movement, and mental health notes, assessments, those kinds of things are about to undergo this same type of change. It's something that's being worked on right now. One thing I want to note is that while you, as a clinician, yes, will have to put your formal notes online, like your intake summary, your case conceptualization, and your session notes, you are able to keep what's called psychotherapy notes not on file, right? So you can have a separate case of notes on your clients that are called your psychotherapy notes or shadow records, that perhaps these are things that the client doesn't need to see, but that you made note of during your sessions, okay? And what this is really just a movement toward greater autonomy on the part of the client, greater shared decision-making, and transparency. There are some drawbacks to this. It can promote confusion and worry on the part of the clients, as well as increased burden for the counselors, right? So if, let's say, for example, if your client sees something in the medical chart that they don't understand or is alarming to them, then there's an increased burden on the counselor to respond to those questions and, kind of put out the fire of that anxiety. Let me give you an example of how this could be problematic. So you guys know I've got this. I'll use an example from my own life on the health side of things. So you guys know that I've got this neurological something or another going on. We know that there is a movement on the health side of things to move toward open notes and online notes as well, using something similar to my chart. Well, about a year ago, I had an MRI looking at the brain, and I read the radiology report came up for me to read. And I read it, and I didn't understand much of it, but I did understand the words multiple sclerosis new event. Now, I had access to this about a week before my appointment with my neurologist. This caused about a week of like severe anxiety and depression on my part because I thought I had multiple sclerosis, only to find out when I met my neurologist that they had put that on record for insurance purposes and that I don't actually have multiple sclerosis at this time, et cetera, et cetera. And so that's just one example of, again, someone who put something in the medical chart for insurance purposes so that that MRI could be paid for, but also, where the client, i.e. me or patient, had access to those notes, and it caused quite a bit of alarm as far as confusion and worry, okay? And that same thing could happen with mental health disorders. And this is why informed consent is so important in that process of diagnosing. We certainly don't want to put our clients in a position where they're seeing something in the medical chart online for the first time that we haven't already discussed with them, okay? Let's see. So some more points that came out of that article is that if we are giving patients access to their charts in this way, are we in conflict with our own ethical principle of non-maleficence? Because do we then increase anxiety in our clients? Do we see that there is a risk to self-harm if they're, kind of seeing how severe we are talking about their diagnoses and prognosis? Perhaps there is another part to this that this is going to cause clinicians to oversimplify the way that we write about these things. Sometimes in addition to that, clients have come back or patients have come back and said, I see an error in your notes, right? Or, I don't think that this is accurate. Even though like we know with our expertise, like this is accurate, that the client might be questioning some of these decisions. Another ethical consideration here is the idea of beneficence. We do see greater treatment adherence when clients have access to their notes, right? Again, that's part of that shared decision making. We do see stronger therapeutic reliance or alliance, that stronger relationship and deeper rapport, and the relationship does tend to be sustained for longer when patients have access to their notes. All right, so we've got a few more considerations around this reading of moving forward, what we need to do. We need to consider that this is going to possibly be open source. We need to consider what that means for our clients who may be reading their stuff in public. First of all, like, if it is open source, is it going to be able to be hacked more easily, right? There's a fine line that we have to walk between documenting too much detail and documenting enough detail. This is why I really encourage you when you're writing your case conceptualizations to err on the side of having a shorter case conceptualization. You want to have just enough detail in there so that you can justify what you're doing, but not so much that, it could be a problem if someone picked up that chart and read it. What about when we're treating minors? Perhaps someone who, let's just say we've got a 16-year-old that we're treating and parent access to those notes. What do we do in those situations? What if we're talking about, as a part of our treatment, sexual behaviors that the teen is engaging in, right? But their parents don't know that. These are things that you've got to consider. Using correct names and pronouns is a big one. You know, and I know that clinicians often have questions around, legal name proceedings, right? In particular, with the case of trans clients who perhaps haven't had a legal name change, but they want, but they're going by a different name socially. My recommendation for this, and what I always teach, is to have that legal name on the first page of the document in the intake summary. And then from there out, use their preferred name. You've got it recorded only in one spot, for those legal needs, and then use the preferred pronouns throughout the rest of the chart. This will absolutely help with feelings of dysphoria with those clients. However, we've got to consider what to do around this when the individual is a minor and perhaps the parent doesn't know that they are identifying with a different or new gender identity or gender expression, okay? Okay. All right. Yes, I think that covers it. All right. This article from 2017, Technology Use in Mental Health Practice, is one that we are leaning on quite heavily these days. I post this table here for you to go over and to make sure that, you at least have seen this, right? I'm not going to ask about this on your final exam, but I do want you to at least know this. Many times the technology use that is occurring in practice, if you're working for an agency or organization, they're going to deal with all of this part of things, right? They're going to make sure that your platform that you're using is HIPAA compliant and FERPA compliant, whatever their agency goes by, right? So for example, I was setting up a telemental health clinic at Mississippi State University last year. We had received funding from the state to provide free telehealth services to children across the state. Just because I was the administrator over this project and developing kind of the clinic and how we would disseminate these services, I didn't have a choice in the technology that we used. That was all determined by the university, right? They already had HIPAA compliant features and platforms that they were using. And also, I will note that because it was a school, we also had to go by FERPA standards as well. So we had to use HIPAA and FERPA standards. But anyway, my point is all of the encryption technology, the network requirements, and some of those platforms will typically be under the purview of the agency or organization. But if you are in private practice and you're doing telehealth therapy, you better know these things and you better have a plan in place for them and have that well documented, because you can't say I didn't know. Just because you say that you didn't know something doesn't let you off the hook. All right, some other things I want you to be aware of in use of technology in practice, because this doesn't only apply to like the actual telehealth therapy sessions. It also applies to electronic record keeping, those types of entities as well. Like if you're going to email your clients, and what does that look like? What can you email? What about text? Like what do we have to consider around all of these things? So I put here many of the different governing bodies that we fall under. HIPAA is always going to be, one entity that we're going to have to work within as clinicians. In addition, high tech. High tech is the act that relates to all of the technology practice that we use. Again, if you are working in a setting with minors, particularly in the school system, you will also be under the purview of FERPA. And then I just put PHI, Private Health Information, as one of those acronyms you may see. These are those pieces of private health information. This is PHI. All of these are considered pieces of private health information that we have to keep confidential, right? I will ask you about what constitutes private health information on your final. I'm going to ask you to pick out which one of these is not private health information. Okay, so we see here, these are all pieces of what we would call PHI. This here is a table of fines that you may encounter if you break any of these violations with technology. And I want you to know here that just not knowing doesn't cut it. You know, you could still be fined quite a large sum just for not knowing. Okay. All right, so as I mentioned, our technology in practice is not just, telehealth services being provided via Zoom or WebEx or Doxy or whatever, right? This includes all of these things. Any electronically written communication, video communication, electronic consent forms, sending and receiving referrals, confidential documents, appointment scheduling, billing processes, payment processes, your hardware, the servers that you use, any location where any piece of PHI, electronic PHI, is accessed, transmitted, or stored, right? So this is a lot. This encompasses quite a bit. And again, you do have to consider these things as a clinician, even working in an agency, because some of these things will pertain to you, particularly as it relates to electronically written communication. That's, I think, the biggest one. Many of these others will be dictated or determined by the agency or organization. All right, and here's just some tech safeguards for you to consider. Again, this is not going to become important for you until later down the line, perhaps in private practice, or if you are seeking telemental health certification, right? So if you do go on to get your telemental health certification, you will have to know all of this. You'll be responsible for knowing it, and if you are ever an administrator, you'll have a headache in figuring some of this out. All right. What I've provided next are a few case vignettes to consider when looking at technology in practice. I'm going to present them on the screen for you guys and allow you to think through that. But first, before I do that, I'm going to skip ahead a few slides and look at what do we do when we don't know what to do. When in doubt, seek it out. That's my motto here. First, turn to the literature and the governing bodies. You can use case law and scientific literature to help you get out of a hole and to help you justify your actions, okay? And I'll give you an example in just a minute of when this has come into play in some things for me personally. Seek training, seek additional training, seek consultation, seek supervision. And finally, lean in on that documenting. Document that you've done these things, even if it is turning to the literature and the governing bodies. So example here, and it's not related to client issues, but it is related to confidentiality and research. I was recently doing a research study where the IRB, of course, was involved because we were using human subjects, yada, yada, yada. Long story short, we were having issues determining we had been attacked by bots, and we were trying to determine if we were then ethically responsible for paying these bots who had accessed our incentives, right? Our lawyers at the university and the IRB were coming together trying to figure out what to do. In this case, because ethics come into play here, my team and I were able to find several literatures citing similar issues and similar incidents and what had been done in those incidents. In each of those incidents, luckily, we were able to find that, hey, when you can determine that this response was by a bot, you don't have to pay it. They didn't pay it. And luckily, we were able to justify that with the literature and not pay $20,000 to bots who had attacked our survey link. Okay, so that's just one example of how maybe you don't have someone who you're able to consult with. Maybe you don't have a supervisor at your disposal, but you can turn to the literature and see what other professionals have done or would do. And you can document that you read XYZ journal article that said do XYZ, right? And I encourage you to do that. All right, flipping back to some of these cases. I'm going to put this up here. Feel free to pause it. I'm going to hang out for a few seconds. Okay. Just think about what you might do in these particular examples. Feel free to discuss it in this week's discussion post. Here's one more. Sorry. This is the one that I was trying to get to. All right. So as you can see in all of these, there was some example of possible breach of confidentiality with those modes of communication. With this one, this is the one that students are typically most stumped on. When you see that delay there, the webcam blinks on and off, you're not sure maybe if it's been hacked. At that point, you would need to quit everything with your session and start again. Just completely X out of everything and reboot the program. All right, so this is quite a long lecture, and I do apologize. For the last several slides here, I'm not going to give you any commentary. These are just some examples of famous dilemmas and ethical dilemmas that very well-known therapists have gotten themselves into, and later were nice enough to share that with other clinicians and kind of what they did. Again, these are famous therapists, okay? Their errors aren't famous, the therapists are, okay? So again, I'm not going to provide commentary. I'm just going to allow you to read through these as you please. Feel free to pause.